So I'm Rod Steeb, for those of you who don't know me, and Expand Your Practice is a thing that we do for all professionals, not just for our members. And I met Cindy at the Attorneys for Family Held Enterprises meeting. I don't remember which one. We had a early one and a later one. And then when her book came out, we'll do the Vanna White thing. So can you see the
Thank
book?
you.
So her book came out at the end of the year. First part of the year is called Preserving a Multi-Generational Wealth. But the key to this is how private family trust company can promote family harmony and provide and positive family dynamics. And I was familiar with family trust companies because I have some clients that have family trust companies. But there's some nuances that have come on, particularly in Ohio, since Cindy wrote the statute that they adopted, or at least the first draft of the statute that they adopted in Ohio. And the reason that we wanted to do this is because, number one, the family trust companies are something for the right client are really powerful for the family, just in terms of being able to do more control over their trust. But number two, it's a phenomenal tool for training the rising gens with all the different committees that you can have in these things. And so with that, I'm going to mute myself and take myself off the screen and leave it to you, Cindy. So
Alrighty,
fire
thanks
away.
so
Thank you for coming.
Yes, thank you, everybody. And so everyone knows I can't see you, so hopefully you can see me on the presentation. But if you do have questions along the way, I cannot see the chat box, but start to put your questions in the chat box. And we are hoping that we have at least a few minutes at the end of our conversation to answer any questions. If not, you will see my email at the end of the presentation. I could talk all day about family trust companies. I've been working in this space for over 23 years now. And I worked with 4 single family offices and numerous, well beyond that, setting up a number of family trust companies. So I really found it to be a powerful tool, as Rod described it, which is why I wrote the book and wanted to get that book out. And it's a preview of the book. It's written for layman's terms, so it's not a technical legal book. It is really designed to help advisors and families of wealth understand how a family trust company may help them. They're not for everyone. I don't think any planning strategy really, there's no one size fits all, but the family trust companies can really, I think, be a very powerful tool. So let's go ahead and get started. Let me walk through a little bit. I start off getting on the same page because I like to highlight some recurring questions I've heard in those 23 years in helping people understand them. First of all, I want to talk a little bit about the difference between a family office and a private family trust company. So let me address why I call it a private family trust company here as well, because I frequently get questions, what's the difference between a private trust company, private family trust company, and a family trust company? Basically, there is no difference. So we're going to talk more specifically about what that private family trust company is. But here in Ohio, I was actually involved. I wrote the original version of the legislation that ultimately became the Ohio Family Trust Company Act. And Ohio joined the statute, or it passed in 2016. The legislators that we spent 2 years explaining what this statute could do for Ohio and Ohio families and surrounding states. You do not have to be in Ohio to avail yourself of this statute. We would just set the trust company up in the state of Ohio and follow some of the formalities here for Ohio. But the legislators here didn't like the word private. They felt that it really wasn't descriptive. And so here in Ohio, we call them family trust companies. Other states call them private trust companies. Some states call them private family trust companies. And the state of Delaware actually refers to them as limited purpose trust companies. So, if you're asking about it, I found that people got very confused about it. They're all the same entity. It's all the same concept. It's just each state, because a family trust company is state statute authorized, each legislative body had a different approach to it, or the drafter of their statute. So that's why you'll see, and sometimes I try to stick with Ohio language since I'm actually physically in Ohio and was involved in the Ohio Family Trust Company Act. I mostly say family trust companies, sometimes because I've been in this space for 23 years and have been president and involved in other private trust companies. Sometimes I'll default to that. So know that it's the same thing. But let's back up and start. It's not a family office. So that I think is the first confusion that I've heard a lot about. People think that a family trust company is the same as a family office. They're very different and they can do very different services. So for example, a family office is really designed to set up an entity that serves the family, and the family decides what services are offered. So you'll see on the screen, it can be everything: tax and accounting, lifestyle, concierge service, legal, tax, investment, governance. It's a wide range of services. And that entity can be set up in any state in pretty much any structure. It can be, having set them up, they can be a very expensive entity because basically you try to bring in the services and offer many of those services in-house and just for the family. Frequently, you will hear a family office, you need 200 million of liquidity to really seriously consider and make it cost effective. That's a number that I may or may not agree with, but it is a much larger number than you'll hear me refer to for a private family trust company. So for private family trust companies, it's an entity that can only be set up in certain states. So I've already indicated that there are only certain states that you can actually set one of these entities up. And that is because it's state statute authorized to grant the entity what we refer to as fiduciary powers. So we're basically saying that this trust company, which is a corporate trust company, can have its own trustee powers to serve as trustee of all of the family trusts. And there are limitations to that, but we'll talk about those when we start to get deeper into the presentation. I do have a number of clients who have started to offer some light family office services out of their family trust company. So it's serving a blend, but they really started because they were looking to the fact that they had all of these trusts that were set up by the family for the family, and they really struggled with who should serve as trustee of that trust. So they looked at it and said, the trust company or trust is where the family is already together, and I refer to it together in the same ship. The family is together in the same ship because frequently family members are all beneficiaries of a trust or trust, and those can hold the family wealth and over the family business. So I do say a family office cannot be a family trust company, but a family trust company can be a family office. So that's the first thing. Wanted to get everyone on the same page. And I referenced 200 million for the family office. I have seen success at the private family trust company down to assets of 20 million. And obviously that's a much more simplified structure and version, but that smaller, structure, because the family is all together, they're already doing wealth transfer planning to get ownership of a business out of an estate to protect the business. So it can be structured very cost effectively because the family really determines what services are offered and what you do. So it's a much different starting point to make it available to families. Moving on to the next, let's stay on the same page, and that is that I make a distinction between succession planning and shareholder transition planning. Most people just use the word succession planning and they lump a lot of things into succession planning, whether it's in the business or with the family. I think there's so much focus on succession planning within the company. So within, who's the manager? Is it a family CEO? Is it a non-family CEO? If it is a family CEO, how do you pick between the rising generation family members? Who brings the right expertise or leadership to that? There's lots of time and focus that happens on that, strategy and execution of it. As important, if not more important in some ways, there's what I refer to as the shareholder transition planning. That is who owns the shares, who owns the company, How do they own the company? Do they own the company outright? Do they own the company as beneficial owners through the fact that they're beneficiary of a trust that holds the ownership of the company or the wealth? I think that area also deserves as much, if not more time, as I said, focus, because it's very important. There are so many things about that transition, particularly in a family business, of how the ownership of the company is. So all of that kind of rolls into thinking about trust and a trust structure. So, let's when I'm talking and when we're talking about the trust company structure, let's all keep in mind we're focusing on the shareholder side. We're focusing on how the shares are passed on to future generations. Nothing needs to change on the business side. So if there's an operating company board, it stays the same. What changes is the trust company, depending upon how many shares they own, may be involved in voting for those directors on the family business board. But as far as the operation of running the business, that really stays within the company, and the management in the strategy is part of the succession planning. So I'm here to talk about today and really focus on that shareholder transition planning. So one of the ways to implement it is through trust. And I've already mentioned this a little bit, that when you're setting up trust, most trusts or most states today, you can set up trust, which you can opt out what lawyers call as rule against perpetuities. I'm a lawyer. I try not to use legalese, so forgive me when I throw one in there. But if we have some attorneys on board, they will understand that. But if you can opt out of a rule against perpetuities, it essentially means the trust can go on in perpetuity forever. So that really changes how to think about the trustee. So when you're doing trust planning and moving assets out of the estate to minimize or avoid the estate tax, which is any assets in your estate after you've used your lifetime exemption, then once you move them into the trust, the grantor or settler does, but then who's the trustee? Who's the person responsible for overseeing these assets? Who's the person who invests these assets? Who's the person that votes family business assets? Who's the person that works with future generations to think about discretionary distributions and what's appropriate? Who's working with, grandchildren or great-grandchildren? Many times people know today who they would work with. So your choices really are the three that you see on the screen. So you have your traditional corporate trustee, and I've put characteristics here. You can look at each one of these characteristics, and some people may consider one a pro, and some people may consider the same characteristic a con, but there are pros and cons to each. So with your traditional corporate trustee, that would typically be, banks or, other trust companies. And what's great about those is they align with their entities that go on in perpetuity. So that's one of the greatest advantages where people would turn to a corporate trustee, because chances are they'll exist now and into the future. They also can, be very, very professional. They also could be litigious avoiding, so much more conservative policies, and their, personnel changes for good reasons and not good reasons. You may have someone leave, but you also may have someone promoted. So who you're working with today may not be who you work with tomorrow, and will highly unlikely be who your grandchildren will work with. So thinking into the future. And, I'm working with a client right now. The main reason that they are considering a trust company is they always had a corporate trustee as their fallback plan, and the entire team that they work with decided that they were no longer aligned with the philosophy of the corporate trustee, so they left the organization. So they are looking at a family trust company for that in perpetuity piece that they, can go on now and into the future. However, most of the clients that I do work with have individual trustees as the trustees. And a lot of reasons they do that is for privacy and confidentiality, because a traditional corporate trustee would need to know things about the business or the wealth, And they also have, at a corporate trustee level, frequently the pressure to diversify the assets. So they typically want to have a diversity of the assets. So if a family that who has wealth, they may want to do alternative investing or something a little riskier. The corporate trustee may not be comfortable with that. In the same vein with the family business, if that's the concentrated asset and the asset that's primarily owned by the trust, they may be uncomfortable with that as well. So most of my clients that I work with really go down the individual trustee route, and which, individuals, somebody within the family, maybe somebody in the different family branch, there's a lot of comfort that comes to that. They know the family, they know the business, they know the values of the family, they know what the business means, they typically know the family story. They typically don't charge anything, or if it is, it's something very small. So the things that we worry about there is that, are they going to say no when they should say no for a distribution, for example? Or are they going to say yes when maybe they shouldn't, or should say yes, and they don't because they have some bias, related to some history with the beneficiary. So it's also can be really uncomfortable. And I'll give a perfect example of this. I had a client that I worked with that the beneficiary was struggling with infertility. Her uncle was the trustee of her trust. So she was in a position where, to ask for a distribution to cover those expenses, she was going to have to go talk to her uncle. And she was very uncomfortable with it. It was very private, obviously, and painful conversation. And she ended up asking me to kind of be an intermediary. And really, we really want the beneficiary feeling comfortable with who they go to talk to. And also, I do joke and say sometimes, if you had that interfamily, particularly spouses, or siblings, excuse me, siblings being trustee of other siblings' trust, it can make for disharmony in, Thanksgiving dinner. What if brother is saying no, or sister doesn't want to go to brother, if it's a private situation. So you can create a lot of disharmony with the individuals. The other thing, sometimes the individuals don't realize, they have individual fiduciary liability. So they have liability for the distributions they are or aren't making, as well as how they invest the assets. And they may not be following some formalities and properly documenting their decisions, which also can make issues for them in the future. A lot of people think about, well, I know the beneficiaries today, but you don't know the unknown and unborn heirs. And you don't know what spousal influence that might occur in the future. So you're not sure if your decisions will be challenged at a later date as well. So that individual fiduciary liability is something that they need to be aware of. I'm also seeing an interesting, trend where I have a client right now where the third generation, which is a smaller generation, they've served for each other's trust for years. They're aging. The trust right now structure would say that the next generation becomes trustee of all these trusts. And they pretty much, the younger generations, so I would say, like your, Gen Zs, Gen X, we're really seeing, and the millennials saying, I don't want to know anything about my cousin's financial or personal affairs. I don't want to make investment decisions, and I don't want to make distribution decisions. So I actually have a client that has some pretty long-standing legacy trust, and we are now moving to the FTC because the rising generation has said they don't want to be involved with at that level. I like to say that the private family trust company can bring you the best of both of those worlds. And it's why, my clients are doing this. Basically, you have an entity that the family sets up to be its own corporate trustee. And there are limits to that. They can only serve, trusts that are set up for family members, by family members, or for family members. But you've now create a company, and it can be an LLC or a corporation, and you create a company. So that checks your box that it goes on in perpetuity. So for the trusts that go on in perpetuity, you have an alignment with what your trustee solution is. You can take that, all of the trusts for the family, particularly if there's a family business involved, you have the same trustee. I had a client reach out to me, and it became a client because the second generation had done their estate planning, and they had all picked a different trustee. They realized that the third generation already had a number or a lot of direct ownership, and they need to set up trust. Well, there are 12 of them. And so they realized, oh, now are going to have potentially 12 new trustees. excuse me, and each one of those trustees had a very different understanding of the family business, the family values, as well as what return would they expect from the family business. So what's nice about the trust company is you address all those concerns because the trust company is really full of family values because you have family members serving on the board and the committees, and you can set up the governing documents to reinforce and infuse those that serve in the trust company or those that really have a good understanding of the family values, and we can really cover those in the governing documents. So I'm a huge fan for the right family, for a family trust company, and I think those are the reasons it really is the best of both worlds for families that are doing long-term planning. But let's dive just a little deeper. What is it? And how long has it been around? So a family trust company, and this is based on Ohio statute. So it has to be family owned and controlled, and it has to limit who they serve to a certain family lineage. It's broader than just lineal descendants, though. So some people think, oh, I'm asked frequently, well, if it's just lineal descendants, that's pretty limiting. It's not. So it's lineal descendants, it's spouses of lineal descendants, it's former spouses of lineal descendants. It can be adopted children, it can be stepchildren. So it is a much broader definition, and that's what we refer to as a family client. And that's actually defined in the statute. As I said, it's authorized under state statute. So this is a common definition. When I wrote the very first version of Ohio, I did look at 6 different states to see how they define things. And at that point, I had about 15 years experience in the space. And I tried to pull what I perceived as the best from each one of those statutes. But it is common that it needs to be family owned and controlled. And it can operate as a corporation or as an LLC. And again, it can only serve family clients. So they can't hold themselves out to the public. And they also don't offer typical banking services. So think of it more as a trustee. So a family trust company here in Ohio cannot be a depository. They cannot do, mortgages. Now the trust can do a mortgage, but the trust company itself cannot act as a bank and provide a mortgage or do loans or, hold money as a depository. So those are some of the restrictions. One of the big questions that if a family is interested in a family trust company that I point out very, very early on is the next bullet point. A trust company can be licensed or unlicensed. That's what we call it here in Ohio. I believe all other states call it regulated or unregulated. Some call it chartered or unchartered. But basically, whatever the nomenclature they use is there are some states where the trust company, Ohio being one of them, where if properly set up in who you serve, the trust company is not regulated by the banking authority. A regulated or licensed trust company is under the purview of that state's banking regulator. Therefore, they would be subject to a procedural audit by that banking authority. And, that is, opening the door and frankly increases the cost. So when I cited the 20 million earlier, that's me really thinking about an unlicensed trust company in a truly unlicensed or unregulated state, because that gives the family more control over some of the costs and expenses. So they don't have any fees to pay to the banking regulator. They don't have to cover the expenses of having an audit. They don't have their certain, additional requirements they don't have to do. So for example, here in Ohio, I do say to clients I work with, remember, this is a fiduciary. So act as if you're licensed with, in looking at what the license statutes are, but look at what those requirements are. And if they're something you're comfortable with, let's do that, or let's stretch and consider that. So for example, I will, give you a couple of examples what I mean by that. So here in Ohio, if you are a licensed family trust company, you are required to have $1 million of fidelity, of $1 million fidelity bond. I don't have a single trust company here in the state of Ohio that actually has a fidelity bond of $1 million. I have some that do and some that don't, follow the requirement of $1 million of D&O insurance. There are other ways that they can protect and cover the directors and officers. So some of my clients do that and some of them don't. One thing that all of my clients do is if you're a licensed trust company in the state of Ohio, every year the directors and officers sign an oath saying that they will, to the best of their abilities, follow fiduciary standards and that they recognize that this is a fiduciary, that they sit on the board. It's a very simple oath. We sign it annually. All of my unlicensed trust companies do that because that is, again, looking to the license statutes and trying to follow those. Most of my clients also look at the capital requirement. In Ohio, it's between 200 and 500,000 if you're licensed. So most of my clients try to do that at least to 200,000 or close to that from a capital requirement. But every client is a little different, but we do look at the license requirements, but it's not required. So that's the difference between licensed / regulated versus unlicensed versus unregulated. So I've already talked about that here in Ohio that they launched in 2016. Ohio was a little later to the game, quite frankly, and they really started being formed in the 1990s. Rockefeller Trust Company was one of the early adopters, chartering in New York, and in 97 under Delaware's limited purpose trust company statutes. But there are many states, and I've listed a number of them on the slide deck, that have licensed and unlicensed. So, for example, South Dakota is truly only a licensed state or regulated state. They don't offer the other option. So those are all the things, as I said early on, to think about as you're thinking about this, thinking about which state, make sure that you have or are willing at least to have some meetings and some connection to that state in considering it. But one of the first things is to consider, for example, Wyoming has clearly regulated and unregulated. And in fact, when I was authoring the Ohio Trust Company Act, I was president of an unregulated Wyoming-based trust company. And as funny as it may sound, one of the main reasons I wanted to be involved in writing the statute and having it passed in Ohio is it does get old, believe it or not, traveling to Jackson Hole, Wyoming 7 or 8 times a year. It's just a hard place to get to. And I primarily worked when I was there to protect our nexus. And I really was looking forward to something that made it a little easier for me to be able to do it here in the state of Ohio. So, that was for a pretty large trust company, but I was definitely motivated to want to do it in Ohio, which is why I got involved in the statute.
So Cindy, before you go on, there is a question that came in the chat, and that is everybody have to be in the same state? In other words, do all family members have to be?
No.
No.
No, it's a great question. And in fact, I actually have trust companies where I don't have any family members physically in the state of Ohio. So it's a Maryland-based family, and we have the trust company here in Ohio. They come here for meetings, and they've hired, in fact, they've hired my firm to do their administration and physically do work here in the state of Ohio. So we're protecting their nexus because we're operating the trust company in the state of Ohio, but the grantors nor the beneficiaries are here in Ohio. They happen to be Cleveland Browns fans, so we do our board meetings. They come in, they do 2 board meetings a year. One usually is by Zoom, and the other one we just orient around a Browns game. So then we have the meeting and orient around the time that they're in town for the Browns meeting. So that's a great question. So no, the family does not have to be physically in the state. They just have to be willing to engage with individuals within the state to do the work and actually come to have meetings there to protect the nexus. So good question. All right. So this is, I know issue spotting is kind of a legal way to think of it, but you can't shake the lawyer out of me completely. But when is, if you're asking certain questions, when is it a good time to think about an FTC? So some of the good times to think about an FTC is if you're doing multi-generational planning. So if families are doing multi-generational planning, they already have, that trustee concern and succession to think about. They already, may know today, and they may be able to do, a line of successor trustees, but typically then they wouldn't know who's going to be here to help my grandchildren, from a trustee perspective. Who's the right person to help my great grandchildren? How do I develop that permanent solution around it? So, if I like to say any family doing multi-generational estate planning should at least understand what a private trust company can do. Again, it may not be for them, but at least understand that it is a solution that the family can set up their own corporate trustee. And is that something they want to do? Because it does engage family members, as Rod talked about. And as I get deeper into the presentation, we're going to specifically talk about some case studies, and I'll show some diagrams of some structures and what motivated family members to set up a trust company and how family are involved. But back to this trustee concern, you've got the privacy and the confidentiality. You don't have personal fiduciary liability anymore. You actually have, you're now really assessed more under what we refer to in the legal community as a business judgment role. Do you have policies and procedures you follow? Do you, document those decisions and have those on file, which an individual trustee would be very well versed, to do and have, written documentation of how they made their decisions or what they relied on. And the trust company puts a structure around it and allows you, to do that. But family members and advisors get to sit at the same table together. So the also nice thing about this from the trustee concerns in the future, it's not uncommon for a grantor to name someone they're comfortable with to be the trustee as an individual. I have seen so frequently what happens is when that generation, which I usually refer to G1, G2, G3, and so on, let's say G2 passes away, G3 frequently comes in, and lets the advisors go because they view those as their parents or their elders advisors, and they want to bring in their own. What's really nice here is those advisors can sit at the table with the current and the rising generation, so you don't lose that institutional knowledge, and they also can be there to help with transitions to the next generation. And I'm going to share a really interesting case study where they did something really interesting in leading on the institutional advisor, and at the same time bringing on a new younger advisor to sit at the same table too, which I think it's been brilliant how it's working out, but I'll share more details about that when I get to the case study. One of the other things is control. Many entrepreneurs, it is a struggle to not be involved, to give up complete dominion and control, to get the assets out of their estate for estate tax purposes. That's hard. One of the things I've been able with the family trust companies is that grantor can have a seat at the table. There are certain committees they cannot serve on, which I'll share that later. And the IRS has, provided guidance for this, but they can be on the board, they can be on the committees. So the grantors can still have a seat at the table, even though they've gotten the assets out of their estate to avoid that 40% estate tax in the future. So, we also within the FTC very uniquely, and you'll see this later in the presentation when I do the case studies, you can very uniquely structure the family trust company that decisions can be, I call it tightened down. And what I mean by tightened down is that frequently I'll do, for example, the family business asset committee. On the family business asset committee, think through the criteria of who can serve on that committee. Does it need to be someone who has been involved in the company? Is it a subset of the board? Is it part of the board, but also, those that are not part of the board? Because, many committee members, are not board members. Who has the knowledge to make the shareholder decisions? Because remember, we're talking about shareholder decisions. Who should serve on the family business asset committee and provide any input for a shareholder decision to the company for the ownership that's in the trust? That can be a much smaller group. And so, as the assets continue to kind of divide down and it's a beneficial ownership, rather than having all these individual trustees, we can really tighten it down and it can be a much smaller group. And I'll show you, in some of the examples, some very different and very creative ways that some of my clients have really decided to populate that family business asset committee just to make sure that they have the right people providing guidance and input to the company. Excuse me. So, but the family can be on the board and can be on the committees, which is great. So you still have that family infused of values. Excuse me, let me get a big gulp of water. My apologies. I've been talking too much today. But another idea or reason that families set them up are for governance. And this goes a bit to what Rod was talking about. So this goes to families that they're looking for opportunities to provide some structure to the family, some transparency, some education. So they're looking to bring the family members in and have them be part of the enterprise and in part of the structure for the family versus feeling like they're on the outside as the beneficiary or on the outside because they don't work with the company. This is a way that you can put some structure into it around the committees, and it really encourages family members who might not be interested in the family business. So, I worked with a family where there was an entire family branch. None of them were involved in the company. And they actually, when I got involved in working with them, they were thinking about pruning. And I refer to pruning as they were thinking about, should we ask for our shares to be redeemed so that, we can go on our way. We're kind of feeling like outsiders. They were geographically dispersed. They weren't living anywhere near where the company's facilities were. And when we set up the family trust company, what we did find is their family was very interested in the governance, in the education and investment of liquidity and thinking about the family's wealth strategy to the point that they completely pivoted, really rejoined and came all in with the family. And ultimately, their family members ended up being leaders at the trust company level. So it's just another place for family members to have that structure, have that connection point. I always say that family glue can happen in so many different places within a family enterprise. And the family trust company and how we set up the committees, it's a great way to put those connection points that people can plug into the family and feel engaged, feel involved, but also be doing something that maybe they have some expertise or some passion around. So this is one of the last things too, is you hear so frequently the tension between a trustee and a beneficiary, and they all really serve very different roles within that trust escape. But, the beneficiary feeling they have to go to the trustee to ask for distributions if it's an individual, putting them in and as part of the trust company really helps with that relationship. And it helps the beneficiary, if they're sitting at the seat at the table of the trustee, start to understand that beneficiaries are stewards of the wealth. What's involved in being, a trustee? What are their rights as the beneficiary? What does that look like? So it really can help smooth that relationship. And anecdotally, you frequently hear, and I've often read, that beneficiaries really don't like being beneficiaries of a trust. Like they don't look at being a trust beneficiary as something positive in their life. They look at it as something negative. They don't feel they have a say. They don't truly understand the relationships. Depends upon the trustee, and trustees can change. So this is actually a great way to bring the family together, integrate the family. And in fact, I'm, working with the client right now. We're launching an FTC, and it has now led to, we're scheduling a family meeting. We're doing education around trust and what does it mean to be a beneficiary, and what is, estate taxes and the family wealth and what they're trying to protect, and, what the grantor's intentions are, kind of what his vision has been for the future. It's a G1 family. So it's really bringing everybody all together under one umbrella so that they can all be hearing and seeing the same things. So let's now put it to life. Let's talk about some fact patterns. So we're going to spend the last time here today really talking about in these to protect confidentiality. They're kind of a combination of a number of different clients for each case study, but the essence is still there. So we're going to talk about in these three case studies what motivated the individual to set up the trust company and what is their situation and what does it look like. So this was a situation where the owner of a company, G1, or actually it's G2, consolidated. He wants to keep the ownership consolidated, and he really wanted his kids to start to understand that they're stewards of the company because none of the kids work in the company and none of them have any interest in working in the company. And the G2 wealth creator had already been through a tense time with families and had to buy his siblings out. So he was very uniquely aware of things that can go wrong, and he wanted to avoid it for his immediate family. And he wanted to sit at the table with the kids and help them understand. So this is a really simple structure. So remember when I said, 20 million and above, and if you're doing trust planning that goes on in perpetuity, you could think about this. This trust company has one trust. So it holds a lot of ownership of the family business asset, but it's one trust. So it's a very simple structure. We still meet twice a year, and the wealth creator is on the board with his kids. There are 2 independent directors involved, but it's a very simple structure. But we follow the formalities of the trust company. The beneficiaries are starting to understand what it means to be a trustee. And the G2 wealth creator is doing additional planning that at his death, most of the ownership of the trust company ends up in trust under the management of the trust company. So he's very forward thinking in wanting to make sure that he's seated at the table with his kids and helping them understand, and that they have a preview of when he passes what to expect when even more assets go into the trust. So it's, a simple structure, but very educational structure. And, they still frankly get the distributions that they would have of dividends if he had given the ownership directly to them in his gifting, because the discretionary distribution committee is meeting and is distributing those dividends, except for some expenses for, the trust tax return. So this happens to be a trust tax return that has to file a separate return if they're any advisor. It's not a grantor trust, it's a non-grantor trust. So, we have to deduct some of those expenses, but everything else goes out to the kids. So they're getting an idea of what could happen and what it could look like, but they're setting it up for success for the future. So this is a schematic, and this is typically what I would look at is the simplest, most basic trust structure. You'll see there's an amendment committee off to the right, and it's a different color green. That actually is a technical committee that the IRS requires, and the amendment committee is there if there are any changes to the governing documents related to tax sensitive powers, which is also technically defined, then the amendment committee has to approve those changes. So I have never had an amendment committee meet because we make sure that we set everything up correctly for tax sensitive powers for the very beginning. And since they're not impacted, I have yet to actually have an amendment committee meet. The amendment committee has to be comprised of independent persons. The other committee that family members or has to be made up of independent persons, I'll rephrase it, which is also defined in the Internal Revenue Code, the discretionary distribution committee. So that was really the area that the IRS, when they provided guidance, was very clear that, if a grantor is sitting at the table, that's fine, but they cannot sit at the table to determine who gets what we refer to as beneficial enjoyment. So they can't sit at the table and decide who gets the distributions. That really needs to be done by the independent persons. What's nice about it, though, is the grantor can sit at the table at the board level, and the board elects who's on these committees. So the discretionary distribution committee elected by the board, at least the grantor's voice is part of that, but it's a voice amongst with the others. But, typically the committee members in most of my structures, not all, but most of my structures are elected on an annual basis. So, it's a way of making sure that they're comfortable with the people on the committees are truly going to be upholding the family's philosophy, values, etc. Another committee is the investment committee. So in this structure, frankly, the investment committee hasn't met yet because they have made the decision right now that the distributions of the dividends continue to happen. So there isn't any money really to invest in the investment committee. So we've not activated it yet in as far as making it active because they've not had assets to invest, but it's in place. So again, we talk about it during our meetings at the investment committee, and we just touch on it in the agenda. The investment committee did not meet. They don't have any, assets, liquid assets currently to invest, and that they, oversight, the investment committee said, yes, we still, believe that our best investment is in the company. And we document that in minutes that they at least have, considered that. And then, but they're set and ready to go for, if in the future there is actually liquidity to invest. Here's the next one. So we're going to kind of grow in complexity. So there's a family-owned business, and they have done a lot of trust planning. So there's been a lot of trusts that have been set up, and they really did their trust planning to minimize taxes. There's some very old legacy trust. There's multi-branches in here. And, the G2 siblings were really at the control level, and they're really looking to start to move things down to the third generation. And they want the decisions to go down to the G3 level. So this is, I apologize, this isn't the multi-trust level. We're going to do one before we get to that one. So this is a trust that holds all the voting shares. So this is a trust that's a little different, that the trust holds all the voting shares in one trust. So let me rethink my fact pattern. I was thinking about a different family. So this is where the second generation, so you've got G2. So G2 right now had all the control of the shares. They had done no planning. They decided as G2 that they didn't want G3 to individually have continue that spread across G3 to make decisions. G2 were very much in lockstep of the ownership of the company. So what they ended up doing is they ended up creating one trust to hold all the voting shares of the company. Then each one of the siblings created different trusts to hold the non-voting shares. So then they created, the separate governance over each. So they had separate governance over each trust. So there was one set of governance. They created a self-perpetuating board over the trust that held the voting shares. And those voting shares then were voted primarily by independent directors. So this was a family that decided that they really wanted independent advisors overseeing the voting shares. They decided, and this is unusual, I will admit this is unusual. Usually the family wants to be part of that control. They decided, it's a large family, that they really wanted to vest their trust in, professionals or experts that had more knowledge to help them guide the company as it continued to grow. They then had a separate board that oversaw the non-voting shares, and that's where the family was involved. So the family was involved there, and they really wanted the, family to oversee or make decisions about, what they did with some of the dividends, because non-voting shares got dividends. So they really looked at the second board, which was really overseeing the non-voting shares, as the family area. So that's what they wanted in that. But what this demonstrates is every family is a little bit different. Every family is trying to accomplish something a little bit different. And this is actually a family that, one size did not fit all. Again, they wanted all independent people with the voting shares. They also decided to meet 4 times a year. That's also very different. the statute requires here in Ohio that the trust company, even if they're regulated or licensed, meets only twice a year. So this family decided the more we get together, the better. We want to meet 4 times a year. So we want to see what to do with, you know, the family engagement. So they actually had an family engagement committee. At each meeting, they started to talk about what the family was doing to stick together. They came up with some really creative solutions. They started doing quarterly Zoom calls just with various updates of the company, or just an opportunity for family members to talk about what's going on in their life. They started doing a newsletter. They started setting up a family portal where they are saving a lot of family historical documents. They also started doing a every other year retreat or camp for the rising generation. In fact, I was so impressed with the camp that they put together for the young rising generation. I encouraged them that they actually could create a company to market it, because they planned a week of incredible activities, really reinforcing entrepreneur, being an entrepreneur. So this was a family that, really wanted the family involved, but not necessarily directly with the family business. So the family really focused on the family activities. They did have, some oversight of dividends, but it was limited. They didn't have a lot of assets or dividends that were building up, but they had family members that were interested in investing. So those family members were able to plug into the entity in the investment committee to learn about asset allocation. Now, they delegated to an investment advisor the actual investing, because as they said to me, we make widgets. This is new to us. We don't really know what to, necessarily do as far as investing. So they went ahead, and what they did is they, relied on that investment manager to educate them so that they could learn. So that was another point of entry to keep the family engaged. To Rod's point early on, where's the family want to be involved? Where do they want to be engaged? There's an engagement committee that there were family members that are really interested in the social aspect, and how do they keep the family together, and how do you make sure that that younger generation is starting to understand the importance of the company, the family values. But these ended up being pretty large committees. Now, the discretionary distribution committee, again, they had limited oversight because there were not a lot of dividends. But what they did decide as a family is the limited dividends they had, that they wanted it really to go to tuition payments for the rising generation. So the discretionary distribution committee happened to be a distribution committee member of one. He actually decided that, he wanted to work with each family branch. So he was very engaged and very involved with the family, and selected because he knew a lot of the family members well and had for a number of years. He actually created a tuition policy for each family, in meeting with each family branch, understanding what was important to them. And then they created that tuition policy so that the family members could also have an idea of what do we need to save, what can we look to the trust to cover. And so it was a great dialogue. And interestingly, the policies were very different across family branches, so they were not the same for each family branch, but he was able to get their input on that. So again, just a very different structure from a family branch perspective. So this is actually a schematic of a different family. So with this family, I'm demonstrating something a little different. So this is a family that wanted to set up a trust company because they wanted to be under the same umbrella, but they are two branches that are very different. So very different in size, very different in some of their philosophies, very different in some of their investing. But they really saw an advantage to, I refer to it as, let's be under the same roof. So let's stay under the same roof and be involved together, but we also want privacy. So this gets a little bit more complicated in its structure, but I really wanted to put this one up here just to briefly demonstrate that you can address those differences in confidentiality. So you will see that they have two discretionary distribution committees. So the two blue boxes at the bottom, the two navy boxes. For privacy and confidentiality, they didn't want to have the same person making discretionary distribution decisions because family members had worked with different individuals and different advisors. They also do have two very different family investing portfolios. It's a real estate family, but they also want to do some together. So this took a lot of brainstorming and working with the family in what they were really trying to accomplish here. But what we ended up accomplishing for them is there were some things that one family branch did that another family branch wasn't involved. So there was one committee with one philosophy, some of it geography. And then the other family branch is doing something a little bit different in the real estate area, but yet they still have some things that they do together. So there are ways that you can structure the trust company in the governing documents that the decisions of, say, family branch number one, business asset committee, their decisions do not have to be ratified by the board. So there's some technical ways we can do that so that the family can still be under the same roof, but some have some own privacy for themselves. So, those two branches and the discretionary distribution committee decisions are not ratified at the FTC board level, which is where you have typically family branches are all together at the board level. So you have privacy and confidentiality there. So here's our fact pattern 3. And I just looked at the time and realized that we have quite a few slides to cover in a short period of time. But I wanted to at least spend a few minutes on this fact pattern, and then we will quickly go through the last few slides. They're more operationally oriented. This is a trust company that I referenced earlier that I thought he did something really creative. G1 had not shared any information with G2, and this is a very successful family business. And G2, one married working in the business, one unmarried not working in the business. And the G2 rising generation did not know much about the trust structures, the business success, or, what they had as far as wealth that would be, as beneficial ownerships. So he decided it was time to start to share more with them, but he wanted to sit at the table with them. So the board consists of the husband, the wife, the two children, but he's the one who picked his current historical institutional advisor who knows a lot about the company. And he also picked someone new that he wanted to sit at the table, someone who was closer to the age of his children. And he wanted that new, we call it the rising director, he wanted that rising director to hear directly from him as the grantor what his intentions, philosophies, what's important to him, and what he would like to see for his family. And so he had the opportunity also to get to know him, to make sure he was comfortable, because if he wasn't comfortable with him, he probably cannot have continued as a director. So this is also a family that wants to meet 4 times a year, and he wants the family to be meeting regularly for an educational perspective and to be able to talk, because this is not a family where communication was comfortable or easy. So this is a way in a little bit more formal structure that they've really now started to talk. The other very interesting thing this family did, I advised against it, his attorneys advised against it, but he decided that he really wanted all decisions at the trust company to have to be unanimous. And it's been really interesting at the investment committee level. We had our reservations, but he looked at his advisor team and said, it's the only way my family will keep talking, and it's working beautifully. We're about 1.5 years into it, and it's working. That they are talking, and they've had disagreements, but they've had to keep talking to make some investment decisions, and they've been able to do that. So that's a little bit more about what this structure is. The other interesting thing I'll highlight about this before we quickly talk about operational, and we'll talk a little bit about some of the other committees that you can have. If you look in the upper right-hand corner, I joke sometimes and say, spouses can be outlaws, in-laws, or value adds. And I've worked for families with each of those 3 perspectives. I've worked for a family where they were not comfortable sharing anything with the spouses. And I've worked with families on the other end that spouses are value adds and they're all in with all the decisions and involvement with the family. This I would say in-law, because we created everything in this structure that the spouses could be involved after that they've been married to the lineal descendant for 15 years. So, they felt at that point they would understand the family and that there would be some longevity to the marriage. As Rod said early on, lots of different committees. We didn't talk about the education committee or the philanthropy committee. Those are also great engagement and entry points for family members to be involved. Those that are interested in philanthropy or, educating the rising generation, not just on trust issues or financial issues. It could be anything. I also, just as closing remarks, I will remind everybody that it is fiduciary. So documentation is important. So we just need to remember that, to document some of the decisions. The one requirement in Ohio, I referenced it, that we have unlicensed. This is my final promotion of Ohio. I'm biased, but I think it's a pretty darn good statute. That I am biased, but this is the only requirement to annually file an affidavit that states that the trust company is authorized to act as an unlicensed trust company. And we basically have covered the provisions of what is involved in what a unlicensed family trust company in Ohio can and can't do. So I know we are 1 minute over. So I don't know if there's any questions in the chat box that we can answer, but as you can tell, I could probably talk all day about family trust companies. I really seen them be a positive impact and bring families together in family harmony. So my apologies for kind of speeding through those last few slides, but you can see my email and my number there. And if you want to read more and more about it, my book is available on Amazon, Barnes and Noble, and Walmart.com as well. So you can dive deeper into it if you're interested. So thank you so much for coming today.
All right. So I got 3 real quick ones. Okay.
I'll try to
One
answer.
is, can it be the trustee for a family foundation?
Yes.
Okay. See, these are going to be quick. Second one is, does everybody have to attend the meeting in person?
So the in-person meeting, you have to have a quorum physically present in the state once a year. And the other one, you just need a quorum.
Okay. It's yeah. So not everybody has to fly in there, do that.
Yeah.
And then one of the questions was, do all the operations still need to be in the state, like in Ohio?
So the answer to that is some of them, so majority. So we usually follow the license part of the statute. And here in Ohio, there are 6 trust administration activities to choose from, but 3 of those need to happen physically in the state of Ohio. And if you're licensed, you do need to engage or employ someone to assist you that's physically located in the state of Ohio. So that's not a yes or no answer, but there's lots of different ways to blend and to get there. Bottom line, as a lawyer, I'm always careful to tell clients, if you're availing yourselves of the laws of a state, you have to have at least some nexus or connection to that state. But here in Ohio, I was very cognizant of that when I wrote the statute. So literally there are 6 things, and if you're licensed, you have to do 3 of them physically in the state. So my clients follow that.
Okay. All right. Those, I think, are all the questions that I saw pop up here. Thank you very much. Hopefully that's a lot of information in an hour. So take advantage of her email, and contact her if you have any other questions. And just in one last thing, more and more and more, the families we're working with that are entrepreneur families, the phrase that's coming up is, we want to make sure that the rising generations know how to be good owners. Not that they have to operate the company, but how do you be a good owner? And this is one of the things that comes out of those committees and being able to work under one roof. They get to without having to operate the company, understand more about it and what they need to know in order to be good owners, which is a valuable piece.
And I like to think of it too, as they learn, it's almost that shift, because they're not direct owners anymore. They're beneficial owners. So it's like, I'm a steward of this company. I get a benefit of it, but how can they learn to be, and I use that phrase throughout the presentation a little bit, stewards. How can they be a good steward of the company? So it's a great opportunity to do that.
Thank you very much. And if you have any other questions, you can get a hold of me or you can get a hold of Cindy.
All right. Thank you so much, everybody.
Thank you.